The gentleman from California, Mr. Berman, is recognized.
Well, thank you very much, Mr. Chairman, and welcome, Attorney General. I want to start by commending you and the Department for your diligent work defending U.S. taxpayers against fraud by government contractors. Every year I watch the total amount recovered for taxpayers under the False Claims Act increase, and I'm grateful for the work that the Department and whistleblowers do together to protect our tax dollars. I think we're now up to something just over $30 billion, and a lot of my colleagues today are focusing on their beefs with you today. I want to talk about this subject because here I think the Justice Department and you are doing this right, and it seems the law is quite effective, and I'd like to make sure it stays that way. Earlier this year, you invited me to take part in a commemoration of the 25th anniversary of the False Claims Act. And though I wasn't able to participate in the panel discussion that followed the main event, I am told that one of the issues discussed on that panel was whether or not we should change how relators are compensated for their efforts in recovering on behalf of the taxpayer. In October of last year, the United States Chamber of Commerce put out a report suggesting that a hard cap of $15 million would be adequate to compensate any relator. Their logic seemed to be that that amount would cover most people's future earnings if their efforts as a whistleblower kept them from working again. The report also suggests that such a cap would not deter whistleblowers from pursuing qui tam cases because in their study of 26 cases, the whistleblowers responded to a question about why they were willing to bring suit, and most of them said that they did it because it was the right thing to do. I believe that, but I also know for a fact that the whistleblowers put themselves at tremendous risk when they make the decision to file suit and try to recover on behalf of the government and the American taxpayer. These cases are expensive to pursue, and they can last for years. They require commitment, and I don't know if a general good feeling about, quote, doing right, unquote, is what will make someone remain committed to the cause for the long haul. Right now, relators can be awarded a percentage between 15 and 30%, depending upon certain factors, such as whether or not the government joined the relators. In my mind, as plaintiffs, in my mind, and I think the history of the Act bears this out, this percentage share encourages a relator to pursue a case until they can recover an amount equal to the entire impact of the fraud, as opposed to settling when the case goes too long, perhaps because they know there is a hard cap and they can only recover so much money. Though the Chamber argues that a hard cap would save the government money, I have to wonder how many cases it would deter or at least reduce the recovery for the taxpayers. In today's world, where some of these cases recover billions of dollars, if a hard cap deterred even one such case, it would be a very costly endeavor for taxpayers. When we considered the False Claims Act amendments in 1986 and in revision since, proposals to enforce a hard cap have not been well received. Of course, there are reasons that defendants fighting qui tam suits would want to limit damages, but I'm more focused on what works best for the taxpayer. I believe what we have now is working well. I sent you a letter on this subject earlier this month, but I wonder if you could share some thoughts with me now about whether the department remains committed to relators being awarded a percent share or if you support a shift to a hard cap.
Well, I have to say that I'm not totally familiar with the proposal that you have described, but I can say that the Act, as it is presently constructed, is working extremely well. And you're right, we asked you to come to the Justice Department to celebrate the success that we've had over the past 25 years with regard to an act that you were instrumental in passing. Over the past 25 years, we've had nearly 8,000 qui tam cases that have been filed that have yielded more than $21 billion in recoveries. $21 billion in recoveries for the United States, $3.4 billion in awards to relators. In fiscal year 2011 alone, the department recovered more than $2.78 billion in qui tam cases. Relators received about $530 million as their statutory shares. The statute, as it is presently constructed, works and works quite well. I would be reluctant to fool around with a formula that for the past 25 years has shown to be an effective tool in getting at fraud and incentivizing people to stay involved in the process and working with government as partners. Now, again, I will look at it, but I have to tell you that on the basis of my examination of the rule as the regulation as it exists, the statute as it exists, I'd be extremely reluctant to tamper with it.